Welcome back, my lord.
Yes.
I am seeking kind indulgence to grant me leave to move to unlisted bill matter. My lord, only for calling the case diary. There is one item has already been filed and connected to the same file. Only for calling the case diary, this matter,
Today, are you not having a reference?
no, my lord, thus tomorrow the bail matter will be listed. That main bail matter connecting to this FIR.
So you are
CD
listing it for tomorrow.
No, my lord, today or my lord may allow me to take up this matter tomorrow.
Have you got the
Yeah, this,
notice that we'll be having a reference at 3:30?
yes, my lord, I am aware of.
Let us see if time permits.
Yeah, my lord, or if not tomorrow, along with bail application number 77. Grateful.
Tomorrow, let us read tomorrow.
Yes.
Well, I'd like to mention number 20 of to be listed tomorrow.
Why urgency? What is supposed to be listed?
Well, the last it is for 2 weeks. And it is more than 2 months. So I would like to see.
Why should you talk to the registry? Why after 2 weeks, why is not been listed?
Violent permits, then the implementer can be taken up tomorrow because there's a criminal case pending before the lower court. So before the last date is the 31st. So
There's no interim order.
no interim order.
Let's see tomorrow.
Most of that.
Ma'am, I'm not sure. I
Yes.
just to mention item number 11.
11.
This matter was listed on 31st August.
11.
I've taken consent from the other side.
Okay. MS K. Wangmo, Learned Government Council. President. Matter may be listed on 31st.
31st.
It's a part matter.
In this AG will appear, madam.
31st, 31/8/2023. As the Learned Advocate General is indisposed, who is supposed to appear in this matter. Consent from other side, petitioner,
Yes, ma'am.
list this matter on 31st. 31/8/2023.
May I, Lordship?
Yes.
Lordship, I beg to mention for listing of a matter, Lordship. Of IA number 129 of 2023
Let's see.
for tomorrow, Lordship.
What is the matter?
It's for Kaba decision. Kaba decision regarding Kaba decision.
Let the Kaba decide.
Lordship, Lordship has passed an interim order here, Lordship, and last occasion it was listed on 14, and accordingly order was given to list after 2 weeks. 2 weeks. So 2 weeks has been completed, Lordship.
You have the interim order.
It's against me, Lordship.
Interim order is against you.
Yes.
Then in that case, you should try some other court.
Lordship,
It will not be vacated. For vacating the interim order.
no, yes, Lordship. For modification, Lordship. For modification, I have filed an IA,
Normally, it will not modify.
which
It will
was
go for
listed on
final
14,
disposal.
which was listed on 14 of this month.
Anyway, I'll see tomorrow.
May your lordship.
Yes.
Lordship, I beg to mention one unlisted matter for withdrawal, your lordship. This matter may be taken up after.
It's a
It's for withdrawal.
writ petition.
It's
of-
a criminal petition, your lordship. Obliged.
May I, Lordship, I intend to, I beg to mention an unlisted item. This may be listed tomorrow. It's a criminal case. We intend to dispose it tomorrow.
No, you may be intending, but this court may not be.
Because
If you are intending, we don't know. How
Yeah.
you, what the permission of the,
because
why, court's permission is required. If you are intending to.
No, no, no. I mean to
dispose of
say,
it, we'll
yeah.
see. Huh?
So it will be really very glad if it is listed for tomorrow's. You understand?
We don't know. If you will see,
Okay. Shall I?
we can't say, we'll see,
Okay. Deeply obliged.
but it should not be out of turn. If it is out of turn, cost will be imposed. Are you ready? It should not be out of turn. If it is out of turn, we'll find out tomorrow, then cost will be imposed. All right,
Deeply obliged.
May I, my lord?
yes,
My lord, I beg to mention item number 5, my lord.
9.
55150. Oh, not 5,
Huh?
5, my lord.
5 or 5?
5. I'm for the respondent. I am representing on behalf
We'll
of.
see, it's item 5.
Yes, my lord.
We'll see, it's in order. We'll see, you be there.
And also, my lord, I beg to mention item number 13 also, my lord.
13 is,
13.
yes,
I'm for the respondent, my lord, on behalf of Ojin Pata.
it's 2019 matter.
Yes, my lord.
Huh?
Yes,
What
ma'am.
is the last, I mean, the oldest matter? Yeah. Any idea?
Not exactly.
When do you want?
Tomorrow. I was under the impression that you would come. I talked to you yesterday.
So when do you want? After 4
Madam,
weeks.
this after 1 week, my lord.
No, my lord, the 2019 matter.
We'll see tomorrow.
Okay,
Your
ma'am.
senior- Where is your senior?
Ojin Pata, my lord. He is out of station, my lord.
Yeah. So in that case,
Okay, madam, will list it tomorrow, my lord.
tomorrow.
Okay, madam.
If he cannot come, you prepare the matter today.
Okay,
we'll
madam.
dispose of it. All right.
Okay, madam. Much obliged, madam.
May I, madam?
Yes.
Madam, I would like to mention item number 15. only. The matter is fixed for supplementary hearing.
Huh?
Supplementary hearing. Item number 15. only.
15.
Yes, sir.
Ah,
My lord, main counsel is has suffering from viral fever, so he
ah,
main counsel B Arun has suffering from viral fever, so he could not
Okay.
travel.
MS, your name?
Yes, Your Honor.
Your name?
Tana
Your name, please.
T Sir,
Ha.
SETH,
Ah.
Tana Sir.
MS so and so, London Council. Appearing on behalf of Mr. B or London Council for the appellant. Submits that the leading counsel, Mr. B Arun, is suffering from viral fevers, for which she prays for listing the matter after 4 weeks,
After 3 weeks.
after 3 weeks. They are not being opposed by the London additional PP. This matter after 3 weeks for the hearing.
May I please, my lord?
Yes.
My lord, I beg to mention one unlisted bail application for today, because just for calling of case that,
Tomorrow.
my lord,
Let us see tomorrow.
my lord, it's already
It's
filed.
anticipatory bail.
No, regular bail, my lord.
We'll see tomorrow.
All right.
Hello, what is this?
This is a bail application, my lord.
Regular,
Yes, regular.
what's
bail
the
application.
offense?
The offense is, my lord, under section 452,
What is 452?
it is house trespassing,
Okay,
and 325,
grievous,
not grievous, my lord.
simple,
Yes,
427.
yes, the 427 is mischief and 506 is criminal intimidation.
Okay,
And here in all cases, my lord, it's all bailable
yes,
except 452,
yes,
house trespass, my lord. Now here, my lord, the accused and the informant, they're family relatives. The accused,
since when you were in the jail, I mean, when
si-
you were arrested.
I was arrested on 9 August 2023, my lord.
9 August, it's been almost 20 days.
20 days.
Yes, madam. Investigation part almost is been completed, my statement of.
We'll call for the CD.
My lord.
We'll see. Which PS case?
It's Itanagar, madam.
Anything else?
No, your lordship, call for the case that is.
Okay. Heard Mr. T. Thakur Nadat counsel for the applicant accused. Applicant is the accused.
Applicants is a cousin brother,
Under counsel for the applicant
accused name Gorat Tamim.
and also heard Mr. T. Learned additional public prosecutor, the state of Arunachal Pradesh. Right. And the application under section 39, 439 of CRPC, comma 1973 has been filed by the petitioner, applicant, who claims to be the cousin brother,
Yes.
cousin brother of the accused, in connection with, for praying for grant of bail in connection with Eternal PS case number 173 of 2023 under section 452, 325, 427, 506 of IPC, who has been arrested on 9/8/2023. Next para, call for the CD. Listed matter after
Madam, I will declare fixed on the fourth matter for CD.
listed matter of
Fourth session, Monday.
04/09/2023.
Obliged, your lordship.
May I please your lordship, this
Yes.
is a subsequent successive bail application, lordship.
Hmm.
Already this honorable court has rejected twice.
What is the
Offense
count?
is 2302, lordship.
302.
Lordship.
Since when?
7/7/2023, lordship.
Huh?
He was arrested on 7/7/2023,
23.
23,
302.
30.
Let us see the FIR.
Lordship, FIR, lordship will find it page 17, lordship, annexure 2 series.
Accused is Tony Lolan.
Totally lordship.
How many accused?
Initially, it was 3 accused. One has been already been
Released.
released. He was not, in fact, he was not involved.
Okay.
He was released. And now 2 is remaining, lordship. And
2 of them are there.
they are lordship.
We'll call for the CD.
Yes, ma'am. This matter will be fixed on Monday, on
Fourth.
4th.
Monday.
Similar nature of case arising out of the same FIR has been,
Other
yes,
accused.
ma'am.
Heard Mr. J.G. Nilan, counsel for the petitioner, and also heard Mr. J. Sri Lalit, public prosecutor for the state of Arunachal Pradesh. This is an application under section 439 of CRPC, 1972, praying for grant of bail of the accused Sri Tony Lolan in connection with Pasigat PS case number 51 of 2021 under section 302, 34 IPC. Call for the CD. Mr. Metro,
4th, ma'am.
Monday,
Monday.
04/09
Yes,
of
sir.
2020.
Manoj.
Yes,
May I please, my lord. My lord, all these petitioners who are 6 in number are by way of this criminal petition under section 482 are challenging the FIR dated 19/6/2023,
yes.
which has been filed in Balupung PS. Balukpung FIR number 5 of 2023, which is 5 on 19/6/2023. My lord,
What is the stage of investigation?
my lord,
Have you appeared?
not yet, my lord. By way of section 41A, the notice has been issued.
It's okay.
To all
You appear,
I have not appeared, my lord.
you appear.
My lord, there is an apprehension that even the FIR was based on only on
Let us see the
vengeance.
FIR. Where's the FIR?
FIR is at, my lord, page number 120, starts from 120.
What is this in Hindi, page 21?
My lord, this is the FIR filed by the petitioner number 1.
Okay,
This page 6, it's a,
it's a counterblast. FIR.
yes, it's a counter FIR only on vengeance by the respondent number 3.
Page, what is your FIR against you?
My FIR against me, the FIR is page number 120.
20.
Yes.
This is also in Hindi.
No, my lord, page number 120, annexure 4.
Okay.
This is on the basis of we are challenging this impugn FIR only, which is an afterthought, my lord, basically, by the respondent number 2 and 3. That is why we are before this honorable court for quashing of this FIR, my lord. Even on the face of the FIR, no offense is made out against all these petitioners, my lord. That's why we are here. And my lord, in this FIR,
Anyway, what can we do today?
my lord, I'm praying for interim protection, at least at this stage.
Investigation, no.
My lord,
You have not appeared. You have been given a notice under section 41A.
my lord,
You appear.
my lord, if I like to appraise this honorable court in a brief nutshell, my lord, my case is way back in 2021, petitioner number 1 and respondent number 2 were married. After the very inception of the marriage, the petitioner number 2 and 3, the whole family member, they're starting harassing petitioner number 1, and they keep on harassing by way of demanding dowry and all those things. Subsequently, this complaint dated 28/11/2022 was filed in SSP Raipur before. Thereafter, the FIR was registered on 4/1/2023, which was on the basis of the complaint of the petitioner number 1. Then after all this, during this whole event,
What is the relationship between you and this respondent?
petitioner number 1 is the wife of the respondent number 3.
Okay,
And the informant respondent number 2 is the father-in-law of the petitioner number 1.
okay.
So thereafter,
So
the
your FIR is has been registered under what?
498A and 34.
498A.
Yes, my lord. So, my lord, my case is basically at this motion, I like to place.
Have you translated this?
Yes, my lord. Translated copies are also there. It starts from the
Page 37.
21 to 62 is the complaint, and my FIR is at 63. It starts from 63, page number 6.
What is the page 37? Annexure 1.
Page number 37. This is the, my lord, that complaint I filed before the SSP Raipur, Chhattisgarh. And the copy was also to the OCPS Raipur, Chhattisgarh. This complaint was initially lodged, and thereafter subsequently the FIR was registered on 4/1/2023.
Accused number 1 is in this complaint, page 37.
Yes,
Accused number 1 is your husband.
yes,
Accused number 1.
yes. Let me check.
Yes, it says something like accused number 1 came to Delhi from Toronto.
Yes, my
So we cannot
husband.
do anything today. We'll issue notice. Can we call for the records?
Lordship,
Record will be there.
Lordship, no, CD will be called for because
CD.
under the investigation only.
All
Well,
of
till
them-
the return
all-
and will
anybody appeared? All the
Lordship,
petitioners?
they
No,
have-
my lord, because
Notice was.
Lordship, notice was
all the
issued, Lordship, on
petitioners.
20th,
Yes.
Lordship, yes.
That's why we are here before.
Nobody appeared.
Nobody appeared, man. There's an apprehension. They are threatening all the petitioners, my lord.
Okay, in that case, you should come up with anticipated bail application.
My all these sections are bailable offenses, my lord.
Okay.
No, Lordship, even though Lordship,
In that case, even if you are arrested, you'll be released.
yeah, Lordship.
If it's a bailable offense.
My lord, they are all from Madhya Pradesh, my lord.
Huh?
And this FIR is only on the basis of vengeance from the father of the husband.
See, Ali, it's very difficult. Investigation, we cannot.
Then I agree, my lord. But in the face of the FIR, my lord, no offense is made out, my lord. There is, my lord is aware of the state of Haryana versus Bhajanlal, my lord.
No,
And-
it's okay, but then that is at the time of final disposal. When we see the records and all,
Agree, my lord.
CD and all,
My lord.
but then not at the behest of your saying so,
My lord.
isn't it?
My lord. My lord,
So
till the
the
returnable, there is at least some protection.
difficulty is, at this stage, interim is not possible. And just show me any judgment that the investigation can be stayed on the petition of 482.
My lord, I'm relying that on the face
No,
of
but-
the FIR, when
Rest of
no
the things
case
can
is
be
made on
addressed
my
for
lord.
final disposal. Interim is interim.
But
If
till the
there-
return.
if there's anything, I'll immediately grant. Otherwise, it's very difficult.
All right, my lord.
Rather, all the judgments are against that the investigation cannot be stalled. Isn't it?
My lord.
What do you say? You ensure, don't arrest, it's the dispute between the husband and wife.
Lordship, already noticed this issued on Lordship 20th, 6 Lordship. Till now, their Lordship.
Huh?
There already the Lordship was issued on 20th, 6, 2023 Lordship, 41A.
Hmm.
Till now, they have not complied Lordship, and not arrest has been made so far Lordship. So,
What is the consequences of non-compliance of section 41A?
Lordship, actually, here Lordship, in this notice Lordship, it is in the last page, is respect to the failure of the act and comply of the terms and conditions, he may be arrested Lordship, but till now, there's not arrest been made. Lordship, actually, they should have appeared before the Lordship for the investigation purpose only. They have some queries Lordship. It's not like that they will be arrested.
Will you tell your IO,
Lordship.
don't arrest them. We'll
Lordship.
ask him to appear.
My lord,
Lordship,
they-
Arrest
we'll
them,
call
but
for the
release.
CD
You
Lordship.
can arrest them, but then you have to release because. this
Lordship,
not-
available,
not
yes,
offense.
available offense Lordship. They have made the bail application there itself also.
But we understand. Even in bailable offense, we have come across many cases.
No.
So
This is
ensure,
only
ensure
attention
that
Lordship.
even if he, arrested, after interrogation, you release him. You can say
Lordship,
bailable offense.
Lordship.
Will you?
Lordship,
Will you assure?
I'll try Lordship.
And
See-
moreover, my lord, except for petitioner number 1, the other petitioner not been named in the
Your
FIR.
friend is so liberal. She assured that you will not be, even if you are arrested, you will be immediately released. So you go and appear.
My lord, if that can
And
be
we'll
observed.
see,
in
we'll
the-
issue notice
No, sir.
and we'll see at the.
CD may be called
time of
for.
the Disposal. You may have a case also.
No coercive action, my lord, then in that.
No, that we can. We pass an order. Prima facie, and it's according to the best of the understanding of prima facie case of the matter.
Understood.
Not that kind of indirect way of giving a relief. Relief should be direct,
My lord,
isn't it?
my lord.
So bailable offense appear. All right. Mr. S.K. General, valid counsel for the petitioners. 5 petitioners, huh? How many petitioners?
One petition, my lord. 6 petitioners are
6
there.
petitioners. By filing this application under section 482 of CRPC, 1973, the petitioners press for quashing the FIR number 05 of 2023. Being, not FIR, quashing of FIR being Balukpur PS case number 05 of 2023, in the section 341, 323, 504. 34 of IPC. Why 323?
My lord, that is why, my lord, in this FIR is totally fabricated, manufactured, my lord. That is why, my lord, I'm praying for interim, my lord. Even in section 41, invoked by the OC, this is just for harassment to the petitioner, my lord, on the instance of the father of the husband. And if we bear perusal of the FIR, my lord, even there is no wrongful restraint also.
Why your father-in-law is so bad?
Because we have not paid the dowry. He's asking for 50 lakhs with a BMW car. And we being a middle class family, we are unable to, since then, that petitioner or being the wife has been totally harassed. In that fact of the matter, we have also filed a divorce petition, 125 CRPC petition.
What about all those cases in out there?
They are
Raipur
pending
or-
trial, man.
Raipur.
They are all pending, man. Even still the charge sheet is still pending for this, our FIR. Man, this is totally to harass us only from Madhya Pradesh. We have been called, and none of the petitioners have ever been to Balukpung.
I'm just back from Madhya Pradesh.
My lord, this is a totally fabricated affair just to harass the petitioner family, my lord.
Anyway,
Because the father was a CMD in the NIPCO during that time. He's now retired. So all this,
your father,
no, father-in-law
father-in-law.
of the, petitioner number 1. This father and son, they've been trying to mislead the whole police investigating authority in Balukpung.
No,
Even this FIR has been filed after 1 year of the incident.
problem is, we cannot stall the investigation. That's the whole problem.
Yes, and Niharika judgment is there, Lordship. During investigation, there could not be any stay. Niharika judgment is there, Lordship. They are doing investigation that stay should not be granted.
So be Niharika
So
judgment.
today I have not bring, Lordship.
If that is, if you can distinguish that also, facts to facts, facts to facts.
In the investigation process should be done, Lordship, properly, Lordship, because it is merely investigation and Lordship, yes, he's been Lordship.
Anyway,
Lordship.
also you just write her name also. Call for the case diary.
Lordship.
Scan.
Scan copy of the case diary.
We'll see, we'll fix it. We'll sort it. When?
After 1 week, Lordship.
1 week. We'll see that day.
Lordship.
All right.
Fix them. After 7 September.
Call for the scan copy of the case diary.
Okay, we'll try to bring on 7, Lordship, because my friend is like, he's.
11 to 12 September.
Okay, Lordship.
This is the matter on 11/9/2023. We'll see that day.
My lord.
If something is not, and there's nothing, we may.
Yes, my
pass
lord.
appropriate orders. The difficulty is investigation.
Lordship.
In the meantime, you may appear.
Lordship, yes.
My lord.
It
I
may,
will
it
trust.
may give impetus to your matter.
My lord.
Bye-bye.
Obliged, my lord.
Yes, Tagu.
My lord, this is my lord,
Coalition
application.
office. I will call for the, is pending before,
pending for the CGM Teju, my lord.
huh?
CGM Teju, my lord.
What is the offense?
Offense, my lord, 227,
338.
yes, my lord.
What is 338?
338, my lord, rash and negligence, my lord. Causing grievous hurt, rash and negligence, my lord. In fact, my lord, the police, they filed the final reports. And my lord, the offense occurred on, my lord, this accident occurred on 28th October 2021, my lord. Now, he was arrested, my lord, the petitioner arrested on 29 October 2021. And after lapses of 1 year, my lord, the charge sheet was filed. Charge sheet, not charge sheet, my lord, final report. Praying for exonerating the petitioner from the charges, my lord. the final report was filed on September 2, 2023, my lord, after lapse of 1 year. my lord. Now, section, my lord, the one subsection 5 of section 167, it says that in case of offense triable by summon case, my lord, it's a summon case, my lord, the investigation has to be completed within a period of six months, my lord. If in any circumstances, the exceptional case, if it cannot be completed, in that case, IO has to file the application with a proper reason to the magistrate. Only on the permission granted by the magistrate, only this can be carried out beyond the 60 days. And in case if it's not done, then the cognizance taken on such police report would be without jurisdiction, my lord. In this similar case, my lord, our High Court has also held decided 2 cases, my lord. Recently, my lord, this in 2001 also, my lord. I'll just place, my lord.
2001 is not recent.
My lord.
2001 is not a recent matter.
My lord, it's not, my lord, this is similar, batch.
2021 or 2001?
My lord, it's a similar cases, it was decided, my lord,
If it
recent,
is
my lord.
2001,
It's not a recent, my lord.
it's not a recent.
My lord, it's not a recent, in similar cases, my
More
lord.
than 20 years.
Yes, similar, my lord, identical,
23
my
years.
lord, matter, my lord. My lord, para 4, it's relying on the previous decision, my lord, of this honorable court, lord, 1987, my lord. Para 4, my lord. I'll just read, my lord. Mr. So-and-so, my lord, under counsel for petitioner has raised a preliminary point of law and has submitted that investigation could not have continued after a period of 6 months from date of arrest of the accused in view of the subsection section 5 of section 167 of CRPC. In absence of application by investigating police officer to satisfy the court that for a special reason and interest of the justice, continuation of investigation beyond 6 months was necessary. Mr. Chaudhary submits that being the position, the trial of the accused was without jurisdiction and conviction and sentence awarded to him was liable to be set aside. In the instant case, admittedly, the accused was arrested on so-and-so and the investigation was completed and charge sheet was submitted only on so-and-so. That's after lapse of 1 year, my lord. Far beyond the period of 6 months is specified in subsection 5 of subsection 167, my lord. And IO did not file any objection, any application for continuation of investigation beyond the period of 6 months. On this point, Mr. Chaudhary, learned counsel for the petitioner, has placed reliance on the decision in this case in the state of Tripura versus Niraj Singha, another versus so-and-so, reported in so-and-so, 1987, 1 GLR. Here detail has been dealt with, my lord. The one that in case of Niranjit Singh, my lord, it is related to harassment and negligence, my lord. And next continuation, my lord, it starts from bottom line next, my lord. In the instant case also, admittedly, case charge sheet was submitted after 6 months from the date of arrest of the accused. And there is nothing to show that any prayer was made by the investigating agency for exonerating the period of investigation. That being so, the proceeding and conviction and sentence awarded by learned magistrate are set aside, and the impugn order passed by learned additional session judge is also set aside. This is
This is after conviction.
yes, this was done after conviction. Even in after conviction, madam, it says that here in the basic principle, when the magistrate has no jurisdiction to take cognizance and to carry on trial on the charge sheet filed beyond the period of 6 months, madam. That's in view of that matter that was held to be without jurisdiction. Therefore, the conviction was held to be illegal, madam. And in similar line, my lord, the Calcutta High Court also, and just GLR also I have, my lord, 1987, my lord.
So it's a summon case.
Yes, summon case, man. My case.
And report has been filed after the expiry of 6 months.
Yes, my lord. After 1 year, more than one.
After 1 year.
Yes, my lord.
And there's no application for continuation of the investigation.
Yes, my lord. In Calcutta High Court Division Bench also, my lord, held the same, my lord, principle.
Yes, your lordship, in this judgment, your lordship may find out that the finding says the accused was not exonerated in that case. Here, the accused was exonerated, your lordship. No prejudice will cause to the accused here in this case. Why? Because, your lordship, after filing of the final report, the magistrate has taken cognizance on the final report, your lordship. And that can be done by the magistrate on the basis of the prima facie material, your lordship. And now, so far as your lordship,
What magistrate has done?
Magistrate has taken cognizance, my lord.
Cognizance. Then next step is what?
your lordship, taking cognizance, and someone issued, your lordship. And when your lordship, this is the procedure, your lordship, I would like to submit before your lordship. After completion of the investigation, when police file a final report praying for discharge of the accused, three things this magistrate can do. One, accept the final report and discharge it. Second, on the basis of the material collected, the magistrate, if find there is sufficient material to take cognizance, the magistrate can take the cognizance. And third is, your lordship, if magistrate would like drop the proceeding, your lordship, the magistrate will give an opportunity to the victim to file a protest petition, your lordship. And here in this case, your lordship, final report was done. Here he was exonerated by the investigation agency, but the magistrate has taken cognizance on the basis of the material collected by the investigation authority. The fact is different here, your lordship. There, the case which my learned brother is relying, there in the case, the accused was exonerated, your lordship. Here, or not exonerated, but here the accused was exonerated by the investigation authority, your lordship. And so far as your lordship is well aware of the 482 application.
It was conviction and sentence.
Yes, your lordship, but the fact, your lordship, it says then the charge sheet was filed.
What's the provision?
167.
167.
167.
5.
Subsection 5.
Yes, your lordship.
Subsection 5.
Subsection 5. Your lord.
My lord, may I read, my lord?
No, I've read it all. I'm asking him, the submission you are making is, which is that provision?
Your lordship, the judicial pronouncement is there, your lordship. This is the judgment of the Honorable Supreme Court. Your
My
lordship.
lord, that part.
The provision first. Tell me the provision. Judicial pronouncement will come later. We'll see later. What is the provision?
While filing the charge sheet, your lordship.
After the charge sheet,
Yes.
after taking cognizance and all that.
Yes, your lordship.
My lord, that apart, my lord,
Let us learn together.
my
Yes.
lord, that part, my lord, my lord, submit, my lord. My lord, that can be a magistrate, they can take cognizance, my lord. If the final reports or investigation report is filed within the period of 6 months, my lord, when there's no quarrel, my lord. Now here's, my lord, charge sheet has been filed after lapses of 6 months. And if it is investigation, it's going on for beyond 6 months, that it was the incumbent, the duty bound upon the magistrate to stopping the investigation.
So was that provision?
My lord,
167.
yes, 5, my lord. Even Hashunara case, my lord, Khatun case also, Supreme Court, my lord, this has been emphasized, this provision, my lord.
We'll see, we'll go later all those.
My lord. Section 5, my lord, subsection 5 of section 167. If any case, my lord.
Yes.
If in any case trialable by magistrate as a summon case, the investigation is not concluded within a period of 6 months from that on which the accused was arrested, the magistrate shall make an order stopping further investigation into the offense unless the officer making investigation satisfy the magistrate that for a special reason and in interest of justice, a continuation of investigation beyond a period of 6 months is necessary. Now here, my lord, neither IO has filed within period of 6 months, no, they have made the application before the magistrate, and the investigation has not been extended, my lord, period.
Let us see the order of taking cognizance. Anything else there?
My lord, at page 86, my lord.
86. In the meantime, you show us that provision.
The cognizance is, your lordship, in section 190, your lordship.
Page 86, my lord.
Yes.
Dated 24 April 2023, my lord. Shared put up before me, my lord. Teju police has submitted final reports form final report trial against the accused, my lord. Series shown. So the peruse the case record and consider the same. After careful consideration of the case, cognizance is taken offense under 338 of IPC. My lord.
You have been furnished the copy records.
My lord, yes, that's why, my lord, I come up with my. 207, my lord, I've been furnished. My lord.
According to you, once the charge sheet or whatever
My lord.
report is not filed within 60 days.
My lord.
I mean,
Yes, 6 months.
6 months.
Yes.
There could not have been any.
Yes, my lord, they could not, because they,
have taken any.
yes, my lord. It is held to be a non-jurisdiction. My lord.
According to judicial pronouncement.
Yes, ma'am.
But then section 5, I mean subsection
So
5.
5 of
167.
Yes,
Then speak clearly about that.
my lord.
It's about investigation.
Yes, ma'am.
Once you could not complete this investigation within 6 months,
Yes.
magistrate ought to have
Stop, my lord.
passing an order stopping the
Investigation.
unless the
Application is
investigating officer or agency files an application
to the satisfaction of magistrate, my lord.
by giving reasons
Yes, ma'am.
that could not be completed within 6
Yes.
months.
Yes, ma'am. In similar view, my lord, the Calcutta High Court Division, my lord, has also, and in one, my lord, Tripura
But
case, my
all
lord.
the judgments after the conviction and sentence.
My lord, first, my lord, this,
There's not such a stage like which you are approaching it.
my lord,
Is there any case law where the final report was filed or the charge sheet was filed after the expiry of 6 months? And then court has a magistrate has refused
My
to
lord.
take cognizance or the any high court or the Supreme Court says that cognizance could not have been taken by the magistrate.
my lord, you see, my lord, this, the Calcutta High Court, my lord, division bench, it is, my lord, during the trial, my lord, maximum number of the witness was already examined, my lord. In that point of view, my lord, this issue was raised, my lord, that the cognizance is taken,
Issue was raised before the trial court or before the high court?
but before the High Court, my lord.
Can you not go there and place all your these grounds which you are making before this court, before the trial court?
My lord,
This is exactly, Mr. PP,
Yes, your lordship.
that is exactly what I wanted to know. That in such a situation, can the accused go there before the trial court and
Invoking
Invoke-
167 subsection. Yes, your lordship. There is no any bar as such, your lordship.
my lord, the problem is, my lord, since cognizance has already been taken, my lord, now the magistrate has no authority, my lord, has no power to recall its own
Review.
order, my lord.
That
That is, my lord,
I understand.
my lord. That's why, my
So
lord,
just because the magistrate doesn't have the review power.
My
so
lord.
You are before this court.
that is why, my lord.
Though you have a right to represent before the magistrate,
My lord,
because of the
cognizance, my lord.
cognizance.
The once the cognizance is taken, my lord, the magistrate has no power to recall it. That is why, my
Yes.
lord.
And your lordship,
We'll call for the scanned copy of the.
your lordship, I would like to indicate your lordship one, yes, your lordship, but before that, your lordship, I have to clarify some your issues, your lordship.
Yes.
So far as limitation is concerned, your lordship, it is specifically governed by section 468, your lordship, of the CRPC. Limitation, because your lordship, while considering this kind of this application, your lordship, the court has to consider the interest of the victim also, your lordship. Only because of the part of the investigation authority, your lordship, that cannot.
468 something. different.
Or this is altogether different.
There's something. Different. Let us. You work on it, but then let us not at this stage. 460 is something. different.
And so far as your lordship cognizance is concerned, that can be taken by the magistrate, your
Yeah,
lordship.
that's what I'm saying. So you, that's why I want that, want you to show that provision.
Your Lordship, when your Lordship charge sheet is filed under section 173 subsection 2, which is a complete, if it is a complete charge sheet, your Lordship. Under section 190, your Lordship, magistrate take cognizance. And then your Lordship, if prior to that there is an inquiry stage, your Lordship, where magistrate find that there is not a sufficient material, then court will exercise 156 subsection 3. That court will give a direction for further investigation. And even after post conviction or post cognizance, your Lordship.
That's
So
why he agreed. He said, according to him, once the investigating agency or the officer did not file the charge sheet or the report within 6 months.
6 months, yes, sir. In
nothing
summary,
doing.
in
It has
summary.
to be stopped then and there. I have some doubt on it. But then he has shown the judgment. We'll examine that. Whatever the judgment, what is your judgment?
Your Lordship, it's regarding the stage, your Lordship. What power can be exercised by the magistrate at this stage when final report is filed, your Lordship?
But that is not quarrel. I'm not quarreling that part. So far, if it is filed within the period, even if final report is right, of course they can make a call. But the thing is here, it has been filed beyond the period of 6 months. Now that is without jurisdiction.
Is it so? Even if it's filed beyond the 6 months?
No, it's not on that, your Lordship. It's not on that.
67.5, the magistrate had the power to.
It's
take
not there.
cognizance.
It's discussing regarding your Lordship. The
That is there. That is there. Nobody disputing.
Yes,
Where on 167.5? Is not it?
yes, your Lordship. And your Lordship, they ought to have filed at that stage only when there was a delay, your Lordship. After
Madam-
taking cognizance, they are approaching
My
this
lord,
court, your
this is
Lordship. Under
exactly-
482 itself, your Lordship. The 482, your Lordship, the power is very, your Lordship, limited, your Lordship.
But it's inherent.
Inherent, yes, is there, your Lordship, but your Lordship, if they raise this issue before the learned court below, and it was not considered, then they can come for the revision, your Lordship. Why it has not been taken into consideration?
This is exactly what Calcutta High Court said. Issue was raised that why this has not been raised before the magistrate. Now this says this cannot be ground, because even if it's raised or not raised, fact of the matter remains that the provision is specific provision under subsection 5.167 that has been violated. This is right from.
So once it is violated,
My lord.
court can exercise.
Yes, my lord.
Invoke the 482.
Yes, my lord.
Huh?
Yes, my lord.
Is it so?
My lord. Regarding my lord, non-raising this issue, my lord, before the trial court, my lord, it has been, my lord, held that whether it has been raised or not raised, my lord, that will not make difference of the statutory provision, my lord. Once is cognizance taken in violation of the 167 subsection 5, my lord, then itself is illegal, my lord.
Illegal, therefore invoke
Therefore-
482. Is it so?
My lord, the entire proceeding set
It
aside.
is a civil revision, criminal revision. That is, he's pointing out. The additional PP is pointing out.
My lord,
You raised, or else if this is taken up, you file you may file a revision, criminal revision in appropriate provisions of the law, not 482. What's he saying? What he
my lord, one of the my lord case, my lord,
is it
19.
Yes, your Lordship.
PP?
Yes, your
Are
Lordship.
you saying that you have to raise before the trial court?
Yes,
if
Your
it is
Lordship.
not taken care of, they should file a revision petition,
Yes, your Lordship.
not approaching this court by 482.
Yes, your Lordship.
That is what you are saying.
Yes, your Lordship.
My lord,
It is Calcutta High Court, it says so.
my lord, Calcutta High Court, my
That-
lord,
that-
even
there is
Supreme
a-
Court,
there is
my
a
lord.
Violation of provisions of CRPC. In that case, you don't have to raise before the trial court.
Yes, my lord.
You can approach the High Court under 482.
My lord,
Most
that part, my
most
lord, so
probably
far,
That must be a revision petition.
my lord, that part is concerned, my lord. It is not
is
there, my
standard.
lord. Now, only the, whether it
That
can,
is the point which he is raising.
now, my lord, in regarding this aspect, my lord, revision and 482, my lord, the Pepsi, there's one, my lord, there's a decision, my lord, Supreme Court, wherein it has been held, my lord, Pepsi Corporate, something like, my lord, there's there, my lord. It has been held that even if there's a revision provision is there, my lord. Now, 482 cannot be, my lord, inherent power, my lord. There also this issue was raised, my lord. But the
But
court
they-
has,
But take it otherwise.
my lord,
When there's a, the remedy under
My lord.
approaching by way of revision,
my lord,
why unnecessary, why should the inherent power has to be?
my lord,
invoked?
my lord, here, I'm,
So according to you, no revision lies
my lord,
against the cognizance.
my lord, my humble submission, this is the
Is there
error of,
a revision lies is not.
error of jurisdiction, my lord, in case
No,
of error.
revision lies or not
My lord, revision,
against the taking cognizance, taking by the magistrate,
my lord.
revision lies or not?
My lord, the revision part, my lord, can be, but now there's no bar for invoking 482, my lord. That is what the Pepsi, the case says, my lord, in Supreme Court,
No,
my lord.
it's okay, there cannot be a ban. Why should go unnecessary for going for invoking the, when there's a provision for revision?
My lord, my humble submission, my lord. Now I raise the issue of, my lord, error in jurisdiction, my lord.
Ah.
That error in jurisdiction, my lord, is a case, my lord, can be, my lord, the 482, my lord.
Anyway, will issue notice? Is there any, okay, private respondent also, no?
Yes, my lord.
The victim,
In family member, my lord. This is
Huh?
complainant, my lord, complainant, elder brother of the victim, my lord.
informant,
Yes,
or the
my lord.
complainant,
Yes, my lord.
or Mr. T. Tagum, learned counsel to the petitioner, and also heard Mr. T. H. Learned additional public prosecutor to say the government of the police. Next para. By filing this application number 6/482 of CRPC, 1973, the petitioner has pressed for washing of criminal proceeding of AGPS case number 42 of 2021, corresponding to GR case number 76 of 2021 under section 338 IPC, 1860. Pending before the on a court of learned chief judicial magistrate, AG. On the ground of violation of section 167 within bracket 5 bracket close CRPC. comma 72. Next. Notice. Call for the scan copy of LCR, huh?
Yes, my lord.
Yes, your lordship, LCM.
In connection with the here case number 76 of 2021. From the Court of Chief Judicial Magistrate, Teju. Next. The learned counsel to the petitioner. Will it- Notice has to be served to respondent number 2.
Yes, your lord.
My lord.
Shall take the steps for service of notice upon the respondent number 2. Registered with 80 within 2 days. List this matter. On receipt of
My brother is saying it's a summary trial, summary case, your lordship. How it can be, your lordship? The offense,
We'll say.
304, under 304A also, he was, 304A was also there, your lordship. 338A, it's for 1 year punishment. Summary for 6 months, your lordship, it should be.
My lord, summary part, my lord, even assuming for 304A, my lord, that's also summary tribal, my
It's
lord.
okay, let us.
The definition
Let us
is,
say next date,
my lord,
let us not make ourselves complicated, all right?
my lord.
So. Nothing,
My lord, my humble submission, my lord, the interim may be, my lord, granted, my lord.
what interim?
My lord, proceeding, my lord, because next date is on 15 September, my lord.
15 September,
Yes, my lord. In the interest of justice, my lord.
I'll grant it, but then you will dispose of before 15 September. Huh?
Yes, your lordship.
My
Will
lord,
dispose of the matter within, before 15 September,
my lord,
huh?
my lord. 11,
Then it's, what's the use of issuing an interim order?
my lord. 11, my lord, 11.
There's a reason I'm saying,
My lord,
once interim order is granted,
my lord.
the petitioner would not, I mean, would not like to pursue the, dispose of the matter.
My lord. My lord, let it be on
Anyway,
11.
no
my-
objection, no objection, what's there, since we are issuing notice, call for the record, so we'll,
Only for,
in the interim, no, not interim, pending production of
LCR.
LCR, the criminal proceedings in GR case number 76 of 2021, pending before the learned court of Chief Judicial Magistrate Tejo. Shall remain
Deeply obliged.
suspended. Shall remain state.
oblige, your lordship.
This is the matter on 11,
My lord, deeply.
11/09/2023. Yes, sir.
My place, Lordship.
What is this offense?
Offense, Lordship, 447
Ah,
and 379, 427, 506.
so many.
447, yes, Lordship. 447 is punishment for criminal trespass,
Okay.
and 379 is punishment for theft.
Hmm.
427 mischief causing damage to the amount of 50 rupees, and 506 criminal intimidation.
What you have,
Lordship,
what you
here,
have stolen?
Lordship, the dispute between the parties, in fact, the petitioner here before your Lordship is not disputing, but it is the complainant who is disputing the title of the jumeland of the petitioner, Lordship.
Have you stolen the jumeland?
No, Lordship.
Okay.
What happened, Lordship, here, the accused person and the complainant are, they are the cousin brother, having common forefather. And there is one ancestral property that is inherited by the complainant. But, accused petitioner. But still the complainant, they are claiming some portion of that land, and they are disputing the title. Accordingly, on that fateful day, when the accused person, he went to his jumeland for collecting some forest materials.
Yes.
Surprisingly, the accused person, the complainant and one of his friends, they appeared. And they exchanged heated argument between the parties. Thereafter, they left the spot both. And after some time, surprisingly, the complainant came to know that the accused person came to know that the complainant has lost the FIR by stating various facts, Lordship. And since this is disputed over the title of the jumeland, where the question of Lordship, the criminal house trespass, theft.
That's what I'm saying. What is the question of theft?
Yes, Lordship. May I take you to the FIR?
What you have, the allegation or
FIR phase 24, Lordship. Nothing, Lordship. Mayor, Lordship. FIR against Rigamdo, the son of late Ligamada of Jordan Blaze, pertaining to attempt to murder, stealing jungle resources, and destroyed the boundary. I have the honor to inform you that accused dismantled the boundary channel, which I have dig, and accused also encroached the boundary by erecting bamboo fencing. It is to inform you that at around 10:45 AM on dated 21/9/2019, I, along with one Sri Jumkarang.
okay, collecting jungle resources.
Yes,
That
Lord.
is called theft.
Yes.
Why you have collected the jungle resources? Huh?
This is my land, Lordship.
Is
Now
not-
it is the complainant who is disputing the title of the land.
Is it not, still this title is in dispute?
Dispute from my side, Lordship,
Okay.
it's under my position, since from the deceased father, who inherited from his father.
Okay, we'll issue notice.
That's my wish.
And the accused petitioner is, Lordship, 64 years old man, who is attending the trial also. So, Lordship.
So why is traveling?
Yes.
Charge already framed.
Huh?
Charge already framed.
Will you stay?
Yeah, LCR, scan copy of
Huh?
LCR, maybe call
Okay.
in meantime.
Heard Mr. K. Lolan and counsel for the petitioner, and also heard Mr. Geeta, the learned additional public prosecutor to the state of Arunachal Pradesh. by this application of section 482 of CRPC, 1973. The petitioner has by filing this application, petitioner has prayed for washing of the criminal proceedings.
Yes, Lordship.
Washing of charge sheet and the consequential criminal proceedings in connection with all of PS case number 86 of 2019
Yes, Lordship.
under section 447, 379, 427, 506 of IPC corresponding to their case number 207 of 2022, pending before the London Judicial Magistrate Allah. Issue notice. Call for the skin copy of PCR from report of Chief Judicial Magistrate Allah. Expect. Then counsel for the petition shall take steps for notice of service of notice upon respond number 2. Register post with within 2 days. List this matter after 4 weeks.
4 weeks.
In the pending production of the skin copy of the case that law courts report. The proceedings in year case number 207 of 2020
Yes, Lordship.
pending before the London Chief Judicial Magistrate Allah. Be will remain state.
Deeply obliged.
May I, my lord?
Hmm.
My lord, in this case, the service upon respondent number 1 to 6 has been completed. And we have brought the same on record by way of an affidavit, my lord.
We're filing affidavit.
Yes, ma'am. The service of notice, 1 to 6.
Why this is before the division?
My lord. It's a criminal petition. Or this matter is being monitored by the principal bench, by the Chief Justice, my lord.
Okay.
It's pertaining to the mob lynching case which happened in Teju.
Okay. So why before this court?
This is altogether a different issue, my lord, different
Huh?
matter. This is a criminal petition, my lord. We are challenging the impugn order passed by the London Trial Court below, wherein the respondent number 1 to 6 were partially discharged from section 302. Ma'am.
Richard.
Yes, ma'am. Partially discharged and framed a charge sheet under section, other sections.
And this has been,
Now we are challenging that order, my lord, the state has.
what should we do? We
My lord,
should do today? What should be done today?
We'll wait for the respondents, my lord, since
Wait. What is the order? Service, it's completed.
completed, my lord, and that has been brought on record by way of an affidavit, my lord.
Oh. This is additional affidavit
My
Huh?
lord, my lord.
held by you.
Yes, my lord.
When it was served, from where do you get it? Hmm? There are 2 additional affidavits.
Altogether 6, my lord.
Huh?
6 additional affidavits.
Okay, so
And
6 persons
6%, my lord.
against 6 persons.
Yes, ma'am.
Okay,
6 respondent. And there's another additional affidavit, my lord. I have missed out to place the FIR on record. So
Hmm.
I have brought that, the copy of
that
FIR
has
by
been
way of,
allowed.
yes, my lord.
When it was served, shown to have been served.
29/6/2023, ma'am.
Not Mr. Gesering, done public visit to the state of Arunachal Pradesh. Expert. The learned PP submits that he has filed an affidavit showing the service of notice upon the respondents. Number 1 to 6.
Yes, ma'am.
Which has been duly effected on
29/6/2023.
29/6. 2023.
Yes, ma'am. 23.
June,
Yes, ma'am.
July, August,
July,
29/6.
Yeah.
Huh?
June, madam,
June.
29 June.
29/6/2023. Though the notice has been duly served upon the respondent. No notice for the respondents next. Be of list this matter after
1 week, madam.
1 week.
1 week.
1 week or 2 weeks. We'll wait for some time. Sometime more. Of course, 2 months.
Okay.
That was 2 weeks. Let us wait for some time. List this matter after 2 weeks for admission.
Deeply appreciate.
Yes, madam.
Yes, Lordship, Lordship, this is also application under post 482 for caution.
Ah.
And Lordship, this is a joint application by petitioner number 1 and 2.
Yes,
And Lordship, this case is arise out of a love affair.
yes.
So,
Foxo,
no Lordship, not POXO.
370.
May I, my lord? My lord, this is joint petition filed by the petitioner invoking inherent power on the basis of mutual settlement, my lord. My lord, offense involved here in this case is 341 IPC, 324. 341 is, my lord, punishment for wrongful restraint, punishable up to 1 month, and this is compoundable, my lord. 341 IPC is, my lord, compoundable. 324 is non-compoundable, my lord. This is, my 324 is voluntary causing grievous harm by dangerous weapon, punishable up to imprisonment up to 3 years. And 354 IPC is authorizing modesty of women. This is punishable from 1 year to extendable up to 5 years, my lord. And 120B is criminal conspiracy, my lord. And 202 IPC is intentionally omission to give information of offense, my lord. This is also non-compoundable, my lord, punishable up to 6 months, my lord. My lord, may take my lord to FIR, my lord. FIR is in page number 21, my lord. 21, my lord, 21.
21.
Yes, my lord. Type copy is page number 21. My lord, this actually incident occurred in the year 2019. This incident took place between supporters of 2 rival MLA candidates, my lord, during 2019 assembly election, my lord. And my lord, may I read the FIR, my lord. Complaint against the below mentioned person who attempt to murder, criminal trespass, wrongful restraint, outrage the modesty of women, and use of firearms against us. That on dated so-and-so, while we were at our village JK to cast vote in the simultaneous assembly and parliament election, around 50 members led by so-and-so, 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 abused and surrounded our house at our 3 hours and tried forcefully to enter our house and kill us all. We somehow restrained and escaped the immediate death. That again at around 5 hours, the same group surrounded our house, armed with lethal weapons like dao, iron rods, and sticks. So and so was even carrying a revolver along with dao. We pleaded with them to leave us alone and let us vote. But they were hell-bent to killing us. Therefore, we forcefully pushed the door open and barred onto with dowels and iron rods. See, so and so also tried to shoot us with his revolver. The said fire person even tore apart the clothes of ours. We thereafter somehow managed to escape the mob. The said person even tore apart the clothes of Srimati so and so and Srimati so and so and threatened them to parade naked in the village. As such, in order to protect the dignity of women, a fight ensued between the mob and us. When we were beaten severely by the mob, led by the said 5% and injured using rods and dowels, had it not been the intervention of some elders, we and our family would have been killed. My lord, this is the allegation, my lord. Initially, my lord, in this case, my lord, police has registered also at the section 27 of Arms Act was also registered, my lord. But during framing of charges, my lord, Arms Act was dropped, my lord. My lord will find charge sheet, charge frame in the phase 101, my lord.
10?
101, man. 100, man. 100. 100. And this is the charge framed by the learned Chief Judicial Magistrate, my lord. The offense here is, my lord, 341, first one. Second is 324, causing grievous hurt by dangerous weapon, and 354, 120V, and 202, my lord. Therefore, my lord, section 27 of Arms Act was dropped during preview of charges, my lord. And now, my lord, 108, my lord. This is the deed of family settlement, my lord. Page number 108, my lord. Deed of settlement, my lord. The settlement was entered between, my lord, the alleged accused persons numbering 7 and this my lord, informant as well as the victim, my lord. My lord, they all are actually, my lord, clan family members, my lord. And they all are from the same village, my lord. So, my lord, now they are living harmoniously together, my lord.
With the first party?
My lord.
First party is who?
First party is the alleged accused person, my lord.
Accused person.
Accused person.
7.
Yes, my lord. Numbering 7, my lord. Yes, my lord. Accused person. First party is accused person. My lord, so first person is, my lord, informant, my lord.
Informant.
Yes, my lord.
Second is?
Second party is, my lord, accused person.
Third is?
Second, second party are actually, my lord, there are 2 men involved.
How?
My lord.
Why it's second and third party?
Actually, my lord, since 354 is also invoked here, so that's why I think they have drafted in
Not
that way, my lord.
you have to be sure why third or second party? Why necessary a third party?
Basically, my lord, this agreement is entered between the, my lord.
Accused and the informant and
Yes,
the victim.
Yes,
Huh?
victim, my lord.
Okay, proceed.
And my lord, they all are family members, my lord, clan brothers, my lord. They belong to one particular clan, my lord. So this offense took place during the heated moment at the time of casting their vote, my lord. And they were supporters of 2 rival candidates, my lord. So my lord is well aware of the, my lord, our apex court pronouncement in such a case, my lord, where the offense, which is not of heinous nature, and the offense which is private in nature, That can be, my lord, set aside and passed on the basis of, my lord, settlement, my lord.
Who are the petitioners?
My lord,
Petitioners, all of them.
yes,
Joint-
all of
joint-
them petition.
joint
Yes,
petition.
my lord. All of
I mean,
them,
All the accused or all the
all the accused as well as the victim, my lord.
informants?
Yes, my lord, victim.
How many?
On numbering 16, my lord.
Huh?
16, my lord, 16.
16.
Yes, my lord.
Accused is up to.
Accused up
number
to
up to
7.
7.
Yes, my lord. 8 to
Okay.
16 are the victim and informant.
Informant and the complainant.
Yes,
Let us see, I mean, the FIR,
my lord.
FIR again. Page 21,
Page 21.
FIR.
Type copy, FIR, page 21. May I-
Informant is 4. Huh?
Informant is, my lord, 4, my lord.
Informants are.
My lord. And my lord,
Charge sheet.
Charge sheet is in,
What is the stage
23, my
of,
lord. PW's, my lord.
stage of,
Now, my lord, is this
Right.
PW's, my lord, PW.
Hmm.
Prosecution witness, my lord. As of now, my lord, 3 PW's has been recorded, my lord. And there are, my lord, 21 PW's here in this case, my lord. So trial will take a time, my lord.
so they are clan members and relatives?
Yes,
so
ma'am.
they have
My
settled
lord,
the
my
matter.
lord. Yes,
Okay,
ma'am.
so
Yes, ma'am.
No chance of conviction.
Yes, my lord. Chances of conviction is remote and bleak, sir.
Lord, altogether in this case, my lord, during framing of charges, 5 sections were charged against the accused person. First is 341, punishment for wrongful restraint. The punishment is for 1 month only. And 324, voluntarily causing hurt by dangerous weapon. The punishment is 3 years, my lord. 354, assault or criminal force to woman with intent to outrage her modesty. The maximum punishment is 5 years. 120B is criminal conspiracy and 202 is 6 months. And non-compoundable matter. Now, may I take my lord to page number 78 to 81. These are the injury reports.
78.
78, my lord, 78, 78. If we peruse the injury report, my lord, it shows that the injury is simple. Altogether, 4 injury reports are, which they have enclosed. It shows that it's a simple injury, my lord. Therefore, in view of the case of a Lakshmi Narayan as well as Kapil Gupta, my lord, since the matter has been settled between the parties, my lord, it's a fit case, my lord.
What do can you? Take down. Mr. Leonard Counsel for the petitioners. And also Mr. J. Shri Leonard Public Prosecutor for the state of Arunachal Pradesh. By filing this application under section 4H2 of CRPC of 1973. The accused informants, the accused and the informants had jointly approached this court on the 6th for washing of the criminal proceedings. Washing of the PS case number 19 of 2019 and charge sheet number 56 of 2020 dated 31/8/2022. 20 and section 452, 324, 325, 354. 120B IPC redo it Section 27 of Arms Act 1959. Corresponding with the GR case number 32 of 2019. Pending with the judicial magistrate. Daporija.
Yes, ma'am.
Daporija. On the ground of the matter being settled between the amongst the parties. Yes. The petitioner number 1227 are the accused persons, and petition number 8 to 16 are the informant and the victim who claims to be the clan members. Next, the genesis of the matter. Is the on 24/2019, an FIR was lodged by the informant against the petitioner number 127. Alleging inter alia that on 11/4/2019, during the assembly and parliamentary election, while they were at their village called JK to cast a vote, around 50 persons led by the accused persons surrounded the house of the informant around 3 p.m.
3 p.m.
and tried to enter the house and attempted to kill them. Around 5 p.m., the same group, there is the accused persons, surrounded the house of the informant with armed with cow, iron rod, and stick. Next paragraph. Accordingly, the police case was registered, being case number 19 of 2019. And the charge sheet was laid on 29 Christoph. On the completion of investigation, charge sheet was laid down on 31/8/2020. And the section, same section, huh? Before the Chief Judicial Magistrate, Daporija, which is numbered as GR case number 32 of 2019. charges have been framed under section 341 of the 34 IPC. No, that is framed under section 341, 324, 354, 123, public 34 of IPC. B should be capital, huh? I didn't put it. Including 202, no? IPC one. Framed against it. Petitioner number 127. During the course of the trial, as on the pre-prosecution witness,
Madam.
the evidence of the pre-prosecution witness has been recorded. As on that,
Yes.
is it pre-prosecution witness have been recorded?
That is his submission, my lord. I have gone through the LCR, my lord. I have not found any such statement. If my lord allows me, I'll just play this.
During the course. Next paragraph. Mr. L. Kudu, and counsel to the petitioners. So next step. The dispute being purely a family matter, as the parties are clan members having misunderstood certain difference, misunderstanding had cropped up certain differences during the last assembly and parliamentary election with regard to the choice of their candidates. Their affairs, of course, had a minor altercation between the amongst the family members. In the election. However, after realizing that realizing the mistakes, the parties have settled, amicably settled their differences.
Yes, please.
Which has
Altogether,
been-
3 PWs has been.
which have been culminated into a family settlement by dated 7/7/2023 by executing the statement, settlement before the executive magistrate. Mahanadi. Next step. You have said the armed section 207 have been omitted.
Has
while
been,
framing the
yes,
charge.
madam, yes, madam.
The learned counsel to the petitioner submits that no charge have been framed under section 27 of the Arms Act against the accused persons, public petitioners petition number 127. Yes. Next one, the learned the petitioner. But the submits that in view of the settlement arrived at between the amongst the parties, among the petitioners. The proceedings. There's a the chances of conviction are bleak, and the proceedings in the present case would be futile. Therefore, the criminal proceedings in GR case number 32 of 2019 may be washed. Next slide. Mr. J. Siri, London Public Prosecutor, the state fairly submits that in view of the settlement among the parties and the offense charge not being of heinous offenses, coupled with the fact that the accused as well as the informant of the victim are the clan members, is said to be a clan member who have approached this court jointly for quashing of the things referred to above. Same maybe. You see, he would not have any objection if this court was the proceedings in the present case. He further submits that in view of the observation and the law enunciated by the Honorable Supreme Court, this may be one amongst the matters which this court may what's the proceedings. Next. I've considered the rebel submission of the consider the parties. The materials available on the court, including the still copy of the case number 32, 2019. There's nothing.
Yes.
Next paragraph. It is noted that the case was registered on the FIR lodged by the petitioner number
8-16.
16. 8, who are the 4 of them? Who has logged the
Oh my God.
you just identify
Informant.
by the informants, namely petitioner number so and so, so and so. You just give the number.
Yes.
You find out that
8, 9, 10, 11.
accordingly an FIR was registered and the charge sheet was filed by the investigating officer. And the section so and so, so all the sections, initial all the sections. Thereafter, the learning trial progress. From the church. Just however, the section 27, no charge was framed against the accused under the Arms Act by omitting section 27 of the Arms Act. During the it transfers the next paragraph. It transfers that during the pendency of the trial, a family settlement has been entered into amongst the accused. I.e., it is number 1 to 7. The informants. That is, you just give the informant
Yes.
what the
Uh,
particular number
8 to 10.
8 to 10. and the victim. Victims. I.e. petition number 11 to 16. Correct. In the family settlement deed, it is provided that they have amicably settled their disputes in the presence of their family members as their clan brothers and sister-in-law of the parties. And it appears to be out of election related differences during the time of voting in the last parliamentary and the assembly election. Next paragraph. In the case of what that, like state of Madhya Pradesh versus
Versus Lakshmi Narayan and
Lakshmi Narayan, so and so. The Honorable Supreme Court has so and so, Paragraph,
paragraph 13.1,
which is reproduced here in below. Paragraph
13.1.
13.1.
Yes, starting from paragraph 13, I'll furnish the judgment.
What is the paragraph? And next paragraph. Thereafter, in the case of
Kapil Gupta versus Estate of NCT of Delhi and another.
Kapil Gupta versus NCT of Delhi, the Honorable Supreme Court has held, which is reproduced here in below. Paragraph
Yes, paragraph 13, same.
13. Lakshmi Narayan, so and so you also give that.
Yes.
I think 15. It is start from 13.
SEC, it's 15.
Let us not give that 13. You start from para 15.
Okay.
Para 15. 15.1, 15 point something like that. It's there, huh? You check with Jason. Having considered the materials available in the courts and the law enunciated and the observation and the law enunciated by the Honorable Supreme Court. Of the considered view that this is one amongst the matters where the proceedings of proceeding that here case 32 no?
Yes.
32 2029 pending before the learned Chief Judicial Magistrate Dr. Rizal. Request to be washed by invoking the inherent power of this court on section 482 of CRPC, 1973. Accordingly. Are you following me? Is it clear? Am I clear? Accordingly, the proceedings in GR case number 32 of 2019, pending before so and so, is hereby set aside and paused. Accordingly, this criminal petition is.
Much obliged.
Yes, give it to her. You take the judgment from
May I Lordship? Lordship, this is also a joint petition filed by petitioner number 1 and 2. Offense Lordship that they have given it's under section 354, 362, 342, 506 of IPC. There are two petitioner Lordship. The petitioner number 1 is the complainant and the petition number is the number 2 is the alleged accused that which number 1 is the informant Lordship. Number 1 is the informant and number 2 is the alleged accused person. Lordship, what is? Yes, Lordship. Lordship, what has happened here?
No, it's sexual harassment.
Sexual,
Sexual harassment.
54A.
No, A1. 54 capital A1.
354. 354A Lordship. It's married Lordship. Lordship, during that since the charge has been framed against the petitioner number 2, like during framing of charge, it has been 354. No Lordship, only 354. That which that it's annexure 3 Lordship is the charge has been framed under 350. Lordship, the charge has been framed by it's in the trial has only the frame has been charged against the petitioner number 2. It's now the prosecution witness will begin since there is a stay by this honorable court Lordship. Lordship, this here Lordship, the petitioner number 1, that is the complainant victim, is the friends of petitioner number 1 or petitioner number 2 younger sister. They are a good friend Lordship. What has happened on intervening night of 12/10 of 2019, 12/8 of 2019? Like the petitioner number 1 had called the petitioner number 2 younger sister to help her in shifting her room rent. Then thereafter Lordship, they went to the petitioner number 2 house. Since Lordship, they are from the same place, like they are from the SEPA, East Coming district. Lordship, after having dinner, like around 11:30, the petitioner number 2 dropped petitioner number 1 to her rent house on her request, Lordship. So there's a Lordship on the incident that took place on 12/8 of 2019 in the intervening night, and the complaint was lodged on 15 on the instant of the petitioner number 1 family member. Lordship, at that point of time, since the petitioner number 2 is a politician by profession, because of some enmity dispute between them, that FIR was lodged. May I take Lordship? The FIR also says in her statement also Lordship, after the incident, she came back to the petitioner number 2 and told the wife of petitioner number 1 to that on the last night, the petitioner number 2 had proposed her for marriage. The petitioner number 2 to petitioner number 1. One says Lordship, then no Lordship, she has not agreed. Since she said, I'm like a sister to you. I'm like a sister to you and you shouldn't be doing this to me. And then like sister, younger, yes, they're good friend. The incident had happened on 12/8 of 2019 and the complaint was lodged on 15 after a gap of 3 days, Lordship. So Lordship, at that since this complaint was basically launched on the pressure built up by the petitioner number 1 family member. But Lordship, like during the course of trial, now they are good friends now. Since they are from the same place, they stay in the same area and they often visit each other. So Lordship, for the made an agreement, a deed of amicable settlement agreement also, which I have annexed in my It's in page 41 also. FIR Lordship, page 16, Mayor. To the officer in charge police station Naharlagan, that is subject FIR again, that is petitioner number 2, so and so presently residing at Julang. Sir, madam, it is to bring to you an immediate notice that I am a student of Don Bosco College, Julang, studying in BA first semester. Presently, I am residing at Opuhil, Naharlagan. That in the evening of 12th August 2019, I was supposed to shift rental house at Julang near Don Bosco College. I called one of my friend, younger sister, Miss Yapung Lamnyo. That is the younger sister of petitioner number 2, to assist me to carry my personal stuff to set rented house. She came around 6 p.m. and accordingly we shifted. After that, I asked her to go back to her home, but she refused to go back alone, and she forced me to drop her back to her brother's house, accused person house, saying that she is not perfect in driving. It could be difficult for her to reach at her brother's house, and moreover, it's already 9 p.m. that we reach at her brother's house at around 9:30 p.m. and she asked me to stay back in her house. Further, it is to inform you that I'm a best friend of accused person's sister, namely Melong Lamnyo, and frequently I used to visit their house, and I'm well acquainted with the family members, and every one of the family members treated me as their sister. We had dinner around 11 p.m. and after taking dinner, his wife went for her bed to taking care of her baby. Then after taking dinner, the accused person started inquiring about me and my whereabouts. I'm staying, and I told him that now me and Yapung had shifted in rented house at Julang, which is nearby college. Then he said he has emergency work in Julang near Don Bosco College area and asked me to drop at my resident house. But I felt hesitation to go with him. But repeated requests by him, I accepted, thinking that morning I should go to the college. And before leaving, I informed same to Yapung Lamnyo that I'm going back to my rental house with my brother. That he's going to drop me there. Thereafter, he started his Fortuner car. I was supposed to sit in the back seat, but he politely asked me to, that sister, Nana, come to front seat. And before reaching my rented house, he speak normally, but it was my shock and surprise. Instead of dropping me at my rented house, he was taking me some place, saying that he has some work at downside of my rented area, forced me to accompany with him, and he will dropping me while returning time, as he is not going to take time. Then he was taking at his workplace, and after some distance, he took me some undisclosed place, saying that he'll take rest here for some time, and I refused to take rest and request him that please drop me to my rented house. And there is at the same time I tried to open door to get down from car, but door was fully controlled and locked by him from his side. Therefore, I could not able to escape. That after he started holding my hand and pulled me aside, I request him, begging him that please, brother, please, please, don't do like this. I am your sister friend. I treated me as your own sister. I am treating you my own brother. Please drop me at my rented house. Then he replied me that he do not have any work, and saying that he is doing it intentionally, and his long back plan to do illegal act with me, and now he got opportunity to have it, and he's rounding me where and there after locking the car door from front side, and he started physically molesting me inside the car and taking some undisclosed place. And at the same time, he was threatening me with dire consequences, saying that I am not listening to his word, he could kill me and take me to Assam. Then I started recording my mobile phone. I will produce the mobile phone recording if required. Then after a long distance of driving, he stopped the car and saying that he is going for urine and asked me to stay inside the car. Then I pretend him that I too have to go to urine, and he thought that there is no chance of fleet away of me, and he allowed me to get down from car. After got down from the car, I escaped from there and hidden myself in jungle. And in the morning, I found myself at Holongi Highway jungle, which is 22 kilometers from Julang Itana. That I spent whole night at the dark forest of Holongi Highway. If I could not be able to run away from him, it would have happened with me without imagining, and how I felt myself lucky enough to escape from such a monster. It is crystal clear that he had all ill intention, as well as he pre-planned to do such illegal act, to taking advantage of dropping me at my rented house. Therefore, I request your good self to arrest him for committing an offense of assault or criminal force and physical molesting, wrongful confinement, and attempt to rape and book under any appropriate section of penal law, and immediately arrest the culprit, prevent him from committing such further offense to any other. In the the down below the note, dealing this, the incident happened on 12/8 of 2019 and it said note delaying for lodging of FR was due to fear of him that he was treating me. Don't disclose the same to any person, but later on I realized I am forgiving him today. It is more dangerous for any other girls/women. I am lodging this FR for interest of women so that the same could not happen with them. You know, in the entire charge sheet also, after the incident, there is a petitioner number and petitioner number. They didn't meet each other. And here the petitioner number 1 went to the house of petitioner number 2 also complaining against him to his wife. And Lordship, since this FIR was, I've made a categorical statement that the FIR was lodged because of the pressure built by the petitioner number 1 family. So Lordship, there was no any ill intention or as they given in the FIR, Lordship. Okay, Lordship. Lordship, I'll like to read the statement of the petitioner number 2, that would be at page 34, Lordship. May I read on? That is petitioner number 2, name so and so, age so and so. On being interrogated, I'm here to state that above mentioned name and address is true. I'm a businessman. On complaint of the case, my sister friend, he used to visit our house sometime. On 12/8 of 2019, when I was having dinner, Nana, complainant, was there in our house and she was the one who was serving me food. While I was having food, she asked me about my health, saying I was looking thin. In this, I told her that nowadays I have started. Yes, Lord. Page 27. I'm a student of Don Bosco College, Julang, studying in BA first semester. Presently, I'm resident of Papu Hill, Nagaland. On evening 12/8 of 2019, as I was supposed to see rental house at Julang near Don Bosco College, I called my best friend, youngest sister, namely Yapung Lamnyo, to assist me to carry personal stuff to my said rented house. She came around 6 p.m. and accordingly we shifted. After that, I asked her to go back to her home, but she refused to go back alone and said she is not perfect in riding scooty, and moreover it was already 9 p.m. so she forced me to drop her.
It's consistent with the FIR. Huh?
Lordship, I'll just take to the next
Whatever
page.
the evidence will be started.
Not yet, Lordship. The evidence yet to start. May I read, Lordship?
Charges have been framed.
Charges have been framed.
You do some research tonight. We'll take up tomorrow.
Okay, Lordship.
What do you say?
Yes, actually, your
Is it a case for washing?
no, not before.
Initially,
First.
it was charges, the charge sheet under section 354 A,
Capital A,
but then charges have been.
subsection 1 of and clause 2.
354.
For A, charge sheet, but at the time of framing of charge,
It's
it
little
was
later.
reflected as 354 only. That is outraging of women modesty.
There
354 is a sexual harassment.
There is minimum.
Minimum is
Minimum is 354.
no.
Prima
Charges
facie-
frame under
No, prima facie, there is a minimum of offense under 354.
for minimum, yes.
Even not.
Harassment,
354A.
yes.
Even if the harassment is, sexual harassment is done away.
Yes, sentence or punishment is
Clearly
different.
established
It is 5 and 7 years.
354.
Yes, 354 is 5 years.
And
And
what about the settlement agreement?
settlement agreement, if my learned friend submits before this court that there is a outcome of enmity between the parties, then this settlement agreement is null and void. Because here in itself, tender apology. Respondent to tender apology, don't not to commit same offense again in future with the respondent, one and with another woman.
In the agreement.
In the agreement, yes. The tender apology.
That is the reason I am giving him a chance.
Yes.
Tomorrow.
Okay,
Okay.
Lordship.
on the prayer of Mr. B. Jamalan, counsel for the petitioner, this matter on 30/08/2023 for admission hearing. We'll give you tomorrow 10 minutes, not more than that,
Yes, Lordship.
and come up with a judgment. You also learned it to be.
Yes.
You are seriously opposing.
Yes, as per Lakshmi, Madam, there is yes,
Seriously opposing on the facts of the matter.
expect this admitted the party. That's why they can arrive into settlement.
You just find out in case even if there is a prima facie case, and if the parties entered into agreement, then
Yes,
tomorrow.
three ton, three.
More so evidence has not been recorded.
This is an initial stage.
No evidence.
Yes,
If tomorrow, if there is no evidence, what will be the, what's the use of having a proceedings?
Lodging
So,
port-
trial.
that is a lodging post apply, and that amounts to the offense under 191 of IPC.
Okay, tomorrow.
All right.
It was mentioned.
My lord,
This has been mentioned.
no, my lord. Yes,
Oh, you made a mention, but we said we'll see after,
yes, my lord.
this is the order. What is this? What is to be done?
May I, Lordship?
Yes,
Lordship, in respect of respondent number 2 and 3,
yes,
we have taken steps upon them through newspaper publications, someone.
yes.
So we have filed one additional affidavit, Lordship, that may be recorded, Lordship.
Okay. When did you file? In respect of respondent number 2,
2 and 3, Lordship.
you are appearing for?
He's appearing for only one.
One respondent.
2 and 3, you have taken
Steps, Lordship, through newspaper publication.
publication. But Mr. J. Not responsible. Appellant
Appellant, Lordship, yes.
and also Mr.
T Minky, my lord.
Huh?
Yes, pardon, my lord.
What's your name?
T Minky, my lord. T Minky.
T. Minky.
Yes, ma'am.
T. Minky, don't say T. Minky. See T.
On behalf of all, pardon, my lord.
T. Minky.
Minky.
Mr. T. Minky, learned counsel for the learned counsel appearing on behalf of Mr. O. Father, learned counsel for the respondent number 1.
Yes, my lord.
Next paragraph. Mr. J. Learned counsel for the appellant submitted. He has taken the steps by publishing, taken steps for notice upon the respondent number 2 and 3. 2 and 3
Lordship.
by way of publication in the newspaper. Through Arunachal Times, huh?
True or not, times
Arunachal
on
Times newspaper on 3/6/2023. Accordingly, he has filed the action, the affidavit in this regard. In view of the above. This matter after 3 weeks.
2 weeks, my lord. 2
2
weeks.
weeks.
Yes.
After 2 weeks. No, before that, non appears for the respondent number 2 and 3. And then, not that, just delete it. However, none appears for respondent number 2 and 3. Next, in view of the above, this matter after 2 weeks.
Much like.
B, please allow.
Yes. IS 4,
This is for, I have taken a step, but report is awaited. This is, I have for make appeal.
IA 4, what?
I have for condonation. One I have for condonation and another is stay execution.
You take the steps.
Steps 2 weeks before I have taken. Second time, first step I have taken before 2 weeks.
AD card receipt back. Let's take it out. After service. AD card receipt back.
Well,
Is it after service? It doesn't indicate anything. What is the amount, award?
award amount is 8,13,000, my lord.
So we'll wait for some time.
Yes, my lord.
Otherwise, 39 days is nothing.
Sometimes.
What is the cause of delay?
Cause of delay is that
Why 39 days delay?
39 is the delay is that we received awarded judgment and award lately after 45 days from the date of judgment. And thereafter, according to the company truth and norms, this was sent for opinion of the senior advocate, and it took some time. And
Okay. Mr. Udeka.
yes, my lord.
Learning principle the appellant. Next one. Office note dated 24/8/2023. Reflects that edited in respect of sole respondent has been received back after causing service of notice to the respondent. Next one. This matter after 3 weeks, 2 weeks.
3 weeks is better, my lord.
3 weeks.
But they are far
Yeah,
away. Yeah.
3 weeks. No, once it is served, doesn't make a difference, whatever.
Yes.
It's anyway, 3 weeks.
Okay. Okay.
The service report for correspondent is still awaited.
What Mr. So and so. Then it counsel for the petitioner, huh?
Yes, on behalf of Gitano.
Service reports in respect of respondents is awaited. This after 3 weeks.
Much obliged.
As per the lordship, the direction of this honorable court, I have taken a step whether this
Service report awards. Mr. Tapak, learning counsel for the petitioner, huh? Who submitted? Yes, steps. Correspondent number. Huh?
May I, my lord?
You are appearing?
Yes, my lord.
Okay.
I'm appearing on behalf of OMOD, my lord.
Huh?
OMOD, my lord.
Correspondent number 1 and 2.
Yes, my lord.
Okay. Then just leave it. Heard Mr. Tita Pagalani comes for the petition. Next para. Mr.
N. Nobang, my lord.
And Novel London.
My lord.
Appearing on behalf of Mr. Omodi.
Yes, my lord.
Omodi
Yes.
submits that he enters appearance on behalf of respondent number 1 and 2. Then.
My lord,
what
I
you
may
want?
be allowed 4 weeks time to counter affidavit, my lord.
And submits that he may be allowed to allow 4 weeks time to file
And-
affidavit in application.
And one more thing, my lord. I will file my affidavit before 1 week, my lord. Wakalat nama, my lord.
No, in that case, you just write. So and so appearing on behalf of. Mr. So and so enters appearance on behalf of respondent number 1 and 2. And undertakes to file the power within 1 week. Just look. This matter after 4 weeks.
Yes.
In the meantime, you may file whatever. Huh?
May I, my lord?
Ah,
In this matter, I'm for the petitioner, my lord.
who is for respondent? The time. So what do you want today?
Step had been taken, my lord.
No, somebody has filed a wakalat nama for respondent 1, 2, and 3. How many respondents?
3, my lord.
Okay. Mr. O Modi and P. Kong King. No. Tea time. Which tea time? Mr. So and so, learned counsel for the petition appears. Mr. Tea time and his associates. A Dukan, learned counsel, have submitted their power on 23/8/2022 on behalf of respondent 1, 2, and 3. However, non-appeals for them today. List this matter after 4 weeks.
Or, my lord, interim order shall remain
Order
continue.
Earlier was itself continue.
Obliged, my lord. May I please, my lord?
Yes,
My lord, this is a case
yes.
of lawmakers.
Huh?
This is case of lawmakers and family dispute arising out of a prior complaint filed by the father of the victim out of anger. This FIR was filed by the father of the victim when he
No.
know
today
about the
It's okay, Today it's for orders.
Yes, sir. Your lordship, on
What is to be done today?
last occasion, CD was sent back, your lordship.
Okay,
So CD may be called for your lordship.
okay, we will call for the CD. It is order is this.
Without the CD or the last occasion, many occasions CD is available.
But
So
today it's not available. It is listed for, I mean,
Sorry.
what was the last order? Huh?
Last order, they have taken adjournment, and prior to that, your lordship, the order has been reflected that CD has
Last
been.
order is which order? Let us see.
prior to adjournment order, the PP was read for send back the CD to the police. So now he's asking for CD, call for the CD again. I think CD is not necessary.
Even without the CD, your lordship, this can be
No,
disqualified.
no, last time on the prayer of London Council with the parties, list this matter after 10 days. On 17th.
Prior to that. Prior to that.
The case diary has been pending for a long time, but the matter has not been heard as yet. Send back the case diary, call for case diary after 2 weeks. It has not been called, we'll have to call again. That's the reason this has been listed for orders today. Heard Mr. L. Torum, T. Torum.
T. Torum.
T. Torum, London Council. And also heard Mr. T. London Edition for the Executive of the State. Listen. Call for the case diary, list after 2 weeks or 1 week. 2 weeks.
Fixed date may be given, your lordship.
Ah.
Fixed date, that will be better because
Ah.
CD has to come.
Any
After
date,
2 weeks.
and after.
No, you decide.
Okay, your lordship. Maybe on 13th, your lordship. 13th of September.
1-3,
Yes,
1-3.
oblige, your lordship.
Lordship, in item number 7, there is something in item number 7, I forgot to mention about interim order.
Item number 7.
Yes,
Interim order is there.
yes.
Item number 7. Yes. Okay, sir. 3:15 we have to rise because of the reference condolence. Otherwise, how long you will take? We have only 10 minutes. Urgency, urgency is there? No urgency. What is the dispute?
Land
Land matter. So there is no urgency.
Lordship, here is the case, Lordship.
You have urgency.
No urgency, Lordship. There is no stay. Here, Lordship,
Well, then we'll pass the stay.
stay.
You are for petitioner.
Yes.
So I will pass the stay. During pendency, the respondent number shall
I am
not
only,
enter upon the land of the petitioner. Huh?
land is already, Lordship, disposed of. Lordship. This is compensation matter, Lordship.
Okay. Okay.
So,
So
Lordship,
that
here,
title is dispute.
yes, Lordship, title is disposed, Lordship. Lordship, here I am representing only
Okay.
three respondent, Lordship.
It's okay, it's okay.
Three respondent, Lordship,
Three
only. I am,
respondent.
yes. Other respondents, as per the record, Lordship, respondent number,
Sir, how many respondents?
there are 9 respondent, Lordship.
Huh?
9 respondents. One is represented by the government.
You appear on behalf of them.
All,
Huh?
all are not authorized. Lordship. I am for 3.
You have
Only-
not been authorized.
Yes, Lordship. I am not authorized, Lordship.
Tell your clients to authorize this person to you also. What's there?
No, Lordship.
Ultimately, you need an adjudication of the matter.
Yes, Lordship. Lordship,
Why are you not the same thing, same family?
Lordship, two is two whom Lordship implemented as a substitute, Lordship. Respondent number 2 is substitute.
That has been substituted.
Yes, substituted is respondent number 3 brothers, Lordship.
Huh?
3 is the brother of respondent number 2, Lordship.
Who are not appearing today?
Lordship, I am
You are for 1, 2, 3.
Yes, 1, 3, 4, Lordship.
Then what about 2?
2 is not represented, Lordship.
All these are same clan, same member. What about 7? 6, 5,
Uh,
any steps?
Yes, I have taken all this.
Lordship, as per record, Lordship, as per order dated 13/08/2021, Lordship.
Of this court,
Yes, Lordship, notice, Lordship.
13.
13/8/2021.
Matter is read for hearing and according face for listing in matter. Okay,
No problem, Lordship. If Lordship is subject to Lordship permissions, this matter may be
no, this court,
in the absence of this respondent, Lordship.
court never doubt the submissions of the learned counsel to their parties. So on the basis of the submission of the learned counsel only, this has been fixed for hearing.
Yes.
There, you cannot doubt. Or do you have any doubt on the
No,
order of this court?
No, Lordship.
Hmm?
Not doubt, Lordship, but just.
No, maybe there could
Yes,
be a
yes, yes, just I.
there could be a mistake also.
No, Lordship, just I'm informing.
They say
Lordship.
error is human. Huh?
No, Lordship, there is no doubt, Lordship, there is in impugn order which challenge.
No, you say, if you, as per the records, if there is any mistake, you let us know. You can, I mean, rectify it.
Yes.
Mistake, no mistake, Lordships. I'm not saying, Lordship, there is
No,
any mistake.
Later
Just-
word would be what?
Lordship, just I'm.
Mr.
point-
Tara,
Yes, Lordship, just I'm
what would
pointing
be
out.
the later word of the mistake?
Just I'm pointing out, Lordship, just responding or not.
Okay.
Madam, next
You-
week, madam. Next week.
Next week. The, due to paucity of that, letter could not be taken up for hearing. Is spread by the, is spread for, by the learned counsel for the parties, list this matter next week for hearing.
Problem.
Right.
Huh? Listed matter over. What about this? Item 16. Let's go first. Due to paucity of time, matter could not be taken up.
Okay.
So what do you want?
Actually, it was for final hearing.
Huh?
Make April. Final hearing.
Yes. But we have to rise at 3:15. There's a
Okay.
reference.
Okay, then
Huh?
next, allow next that.
Due to paucity of time, the matter could not be taken up for hearing. As spread for the learned counsel for the appellant list this matter after
So 15 days.
15 days. 16. We'll have to finish it bond first.
Maybe after 2 weeks.
Huh?
After 2
Due to paucity of the matter will be taken up, list this matter after 2 weeks for hearing. What is the urgency here?
Lordship, I will be allowed to withdraw this.
Okay, okay. MS A undue learned counsel to the petitioner submits that she may be allowed to withdraw this petition. Please stop. Praise it allowed. Please stop. Accordingly, the criminal petition 147 to 2023. 147 of 2023 is disposed of on withdrawal.
Well, dismiss on withdrawal.
Huh?
Dismiss on withdrawal.
What would be the consequences?
Lordship, actually, Lordship, this matter was Lordship, it was not maintainable also, Lordship.
Okay. So it's good. Who, when we use the word dismissal, who gained the most? Huh? How do we gain it? Should I say, Anju, dismiss or
usually-
withdrawal?
Usually, Lordship is like.
Lordship,
I will
it's on
say, it
withdrawal.
will say the criminal petition is
Matter is
147, 2023 is disposed of oblique dismiss on withdrawal.
Lordship.
I don't think there's anything
Otherwise, maybe close, Lordship.
advantage or disadvantage when we say that dismiss or disposed. So let us go for that positive side. Disposed of. or
Otherwise,
withdrawn.
closed lordship.
Obliged.
Disposed and closed on.
Closed.